Part 1, New York Times versus Sullivan. Who are the parties to the case and what facts led to the disputes? The parties to the case are plaintiff Mr. Sullivan and defendant, the New York Times. Factors leading to this dispute between parties were the newspapers printed an advertisement titled, Heed Their Rising Voices. In it, Mr. Sullivan, who was the police commissioner of Montgomery, Alabama, believed it contained liable statements as it detailed inaccuracies pertaining to how the police handled various elements of a civil rights demonstration and a civil rights leader, Martin Luther King Jr. In it was reported the students involved were essentially terrorized by police during what was supposed to be a peaceful demonstration. Police were said to have assigned to man the campus with shotguns and tear gas and made the dining hall inaccessible in response to students protesting and the expulsions of students who led the demonstration. Additionally, it reported the department had bombed Mr. King's home and arrested him numerous times for an array of offenses. Why did Sullivan feel his reputation was damaged by the New York Times publication? Although he was not mentioned specifically, as a leader of the police department, these statements inherently were liable toward him because he allowed officers to engage in this type of conduct and the use of intimidation and violence. Since Sullivan was a public official, what did he have to prove in this particular case? As a public official, Mr. Sullivan had the burden of proving the New York Times printed dislabeled statements with actual malice. Meaning, the writer intentionally printed these statements knowing that they were false, yet proceeded to do so recklessly. What was the U.S. Supreme Court decision, and why did they make that decision? The Supreme Court overturned the original verdict, which ruled in favor of Mr. Sullivan, as the statements were considered liable per se. This meant injury could be applied to the commissioner because he was a representative of the police force. Also, the plaintiff did not have the burden of proving malice. The Supreme Court justice reversed the Alabama court's application of the law citing violation of the First Amendment. This decision supported freedom of the press and media has a right to report on these type of public issues, even if statements may seem to be harsh against the government and public officials. Said rights are guaranteed under the Constitution. Secondly, even though the Times later retracted the advertisement, there was no evidence they printed with malicious intent. There was no legal basis to conclude the plaintiff was personally attacked by the statement made simply because of his job, and it did not specifically mention him. Therefore, Mr. Sullivan did not prove it was published with actual malice. Part 2, Gertz versus Welch. Who are parties to this case? Was the petitioner a private person or a public figure? The involved parties in the case are plaintiff Elmer Gertz and defendant Robert Welch. Justice Powell argued the petitioner was neither a private person or a public figure. What were the alleged defamatory statements about Gertz in the American Opinion article? In the published article, Frame Up, Richard Nicieza and the War on the Police, the writer accused Mr. Gertz of being a communist and a proponent of violently seizing the government. It also made allegations that Gertz was involved in framing Officer Nicieza because he was part of these communist organizations. He further claimed Gertz was part of a planned attack on the Chicago police during a 1968 Democratic convention. Lastly, he stated Mr. Gertz himself had a criminal record. What was done to confirm these accuracies of these allegations against Gertz? The editor did not make any attempts to conduct any research or validate the claims made against Mr. Gertz. He did, however, state he had conducted research on Nisio's case and Mr. Gertz, in fact, harassed Officer Nisio. How do you think these allegations affected Gertz's reputation? Attorneys have the duty of advocating for and defending the legal rights guaranteed to the people under governmental protection. Being falsely associated with groups deemed to be against the police is contradictory to supporting a governmental entity also employed to uphold the law and protect the people. Also, as a definition of libel, the statements can ruin his reputation and livelihood of being an upstanding attorney. These unsubstantiated allegations affected Gertz's reputation as he claimed in his suit as an attorney and a citizen. What would you have done differently than Welch to avoid the lawsuit? The primary action that should have been taking place before printing the statements against Mr. Gertz would be to research to see if there was any truth to them in the first place. We all have entitled to our own viewpoints and opinions about various matters. But as a journalist slash writer, you have the responsibility of putting those views aside and report facts and maintain professionalism and a code of ethics. Texas defamation law. Definition of the Texas law contains three elements. 1. Publication of a statement. 2. The statement of defamatory concerning the plaintiff. And 3. With the requisite degree of fault. Regarding private and public figures, Texas law defines plaintiff as a public official, such as a police officer or a CPS specialist investing an alleged child abuse case and has been providing services to the children involved. They could also be limited purpose public figures, for example, a city council candidate, special counsel for a court, or a broadcast news reporter. Actual malice and negligence state a private figure plaintiff is like what plaintiffs have had to prove in mentioned cases when filing a defamation lawsuit. The defendant must prove there was negligence with respect to the truth and the defamatory statements were false. The defendant made the statements with knowledge the statements were false, but proceeded to do so with reckless disregard to the actual truthfulness and said of said statements. If so, the defendant acted with actual malice. How can you relate with what you've learned from Sullivan and Gertz cases to your future work in the communications industry? Through both cases, I've learned that although we have the right under the First Amendment, and yes, we have the right to express our opinions as part of our freedom of speech and part of our research and reporting. However, we also have a responsibility to maintain journalistic and personal integrity, and it should remain at the forefront. Our intentions, even when we may not agree with every element we are reporting on, holding malicious intent due to our opposing viewpoints, we must ensure we are reporting and communicating with the public, verbally or written, that our research is done with accuracy, fairness, and true representations of facts. I have a responsibility to ensure any news provided is done thoroughly and carefully to avoid making liable statements. The key is having the facts to support what is being said.